Music is exciting and fulfilling. If you can sing or play, you're special, so you'd better see a lawyer. I'm Dan Ringer, and we'll talk about music and the law right now on The Law Works.
From West Virginia Public Broadcasting.
The Law Works is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
There are many legal issues in the music business. My guest is attorney L.Kevin Levine. Kevin, thanks for joining us.
Thank you for having me.
I'm going to give you a hypothetical. My son is a good musician, plays a guitar. He has a couple of buddies who likewise play guitar, play drums, and they're pretty good. They would like to start performing, they'd like to form a little group, and maybe even make a recording or two. What should we worry about?
Well, that's a hard question to answer simplistically. I will tell you that aside from the issues that you get into with copyright, which is automatically where most people's minds go to, you have to deal with or astute business people or music business people should actually think about the formation of the band. So you actually have issues that come up with ownership of not only of songs that perhaps they write together, but of master recordings that they record together. You have issues of just how is the band going to operate? How is it going to function? Going beyond that, you certainly have issues, like I said, where most people go is the more obvious copyright issues, particularly if they're going to be dealing with any what we call cover songs or songs that were written and perhaps recorded by other folks, and they are simply recording or going to be putting out a new recording of a previously existing song.
Well, they're going to do some of that. They're going to record other people's songs. In fact, they're really good, and they can imitate just about anybody. I guess that's what you call a cover band, is when they go out and start playing stuff like that.
Many times they do go by that moniker.
Okay. But they're going to go out and they're going to play at some parties, and maybe if things go right and they're of age, they can go play in some bars and make a little money. They haven't written any of their own songs yet. They're just going to play other people's songs. What do they need to do?
Well, if you say that they've just written their own songs.
Well, they're writing some songs, but they're mostly going to be playing other people's.
I apologize. Well, essentially, if they're looking to perform live, that's a different issue from if they're going to be dealing with putting out CDs or MP3s, digital permanent downloads, as they're more technically known, of those songs. If they're strictly talking about a live performance setting, that's a situation where they do have to pay what are known as performance royalties. Sometimes they're called public performance royalties.
Wait. They aren't even going to go buy the music. They've listened to the records enough, and they've played along enough. They know the words and they know the music. They can't just go play it?
They cannot. I will tell you that two names of organizations out there that it's their sole job is to look out for their membership, which are comprised of songwriters and music publishers, ASCAP and BMI, and a lesser third, or a lesser known third performing rights society is called CSAC. And they create a lot of confusion, quite frankly, even among musicians. In fact, many musicians who have been performing for decades don't fully understand how the publishing world differs from the record label world. And essentially, what those folks do is, if you are performing, let's back up and even take it outside the band context. Anytime there is music being performed, essentially in any public venue, theoretically, the songwriter and the music publisher, if there is a music publisher that owns that particular or administers that particular musical composition, they are entitled to performance royalties. Okay.
So they get money just because I sing Happy Birthday?
Exactly. It's the fact that they wrote that underlying musical composition. Has nothing to do with the actual sound recording which you are listening to. In fact, the artist and the artist you're listening to, or the band you're listening to, for simplicity's sake, they're all artists. But
even if they're not,
even drummers like me, we're still artists. But in the record label that usually owns that particular sound recording or the master, they don't get paid. They're not there. There is not a, at least as we sit here today, there are a lot of strong lobbying efforts trying to change that. But as we sit here today, there is no public performance right in a sound recording, only in the underlying musical composition. And it's a point of confusion. Quite frankly, there are musicians that have enjoyed very, very successful, which is of course a very subjective term, particularly in today's music industry. They've made a lot of money and had a lot of good times doing it, but that don't quite grasp the difference in those two critical areas of copyright. Generally speaking, when we are talking about musical copyrights, we are talking about two types of copyrights, and I could confuse it because invariably when I talk about this, someone says, "Well, wait a minute, isn't the music video also a copyright?" Yeah, that's a different issue. But strictly in terms of recorded music, when you turn on your radio, or when you, to use your example, when you listen to a band play in a bar, you're actually hearing. Or actually, if you're listening to a recording of a band playing in a bar, you're actually listening to two separate copyrights. One in the underlying musical composition. In other words, if you and I decide right now we're going to write a song, and you jot down on your pad of paper, what we come up with, assuming it meets all the criteria for being something worthy of copyright, an original.
And it doesn't take much to be worthy of copyright.
It does not take a lot. It's a very, very low threshold. It has to be in essence, it needs to be a tangible, it needs to be an original expression of an idea that is captured in a tangible medium of expression.
Okay, so if I want to write the Law Works theme song,
sure,
and I'm going to put some words to it, and I'm going to put a little music to it, I take a sheet of paper and I write down the melody line and a few words that go along with that, at least that part of the Law Works theme song is now protected.
That is correct. You own the musical composition. Now, taking it a step further, say that you talk to your son and he and his band are willing to go and cut that particular song for you and to play it at the beginning as your theme song. When they go in the studio and they actually record a particular recording of that underlying musical composition, a second copyright is born, and that's what we know of, or that's what's known as the sound recording. And sometimes they're called masters, sometimes they're called sides. You particularly hear producers talk about going into the studio and cutting sides. That's what they're talking about.
Sound in the old days when there was a vinyl recording,
exactly.
At side A and side B.
Exactly. It harkens back to those days.
Okay, so my kid just wants to play some music, and he's going to go out, and I use the song Happy Birthday as an example because that song Happy Birthday has been the subject of much discussion about copyright. It is a copyrighted song, and every time somebody sings it in public, they're supposed to throw 2 or 3 cents to the family of the guy that wrote it and stuff like that. So they just want to go play a few songs. Are they going to be violating somebody's copyright if they go out in the city park and strike up a concert and play a few songs?
Well, it depends. Now, City Park, I'm not really certain because, frankly, I've never had that issue cross my desk. I will tell you that as a general proposition, when you're dealing with a commercial bar or eating establishment, places that routinely hire live music, it usually it falls on the venue. In fact, it almost always falls on the venue to pay the performance royalties. So they actually pay every year a blanket licensing fee. And as I'm sure you can guess, ASCAP, BMI, and CSAC, the big three performing rights societies or performing rights organizations in the United States, pretty much have it down to a science, to where they offer blanket licenses for different types of retail establishments. They're based on size of establishments. Now, I will tell you, not to get overly technical, there are a few notable exceptions, and quite frankly, again, they're issues that haven't crossed my desk, so I haven't had to look into them too deeply. But I do know that there are certain exceptions to the performing rights royalty that apply to certain size establishments, particularly with eating establishments. And it's down so technical that it even depends upon the number of speakers in the establishment and how far apart they are spaced.
That's to determine the license
exactly.
expense.
And generally that is only going to apply in a terrestrial radio replay type of scenario. It's not going to be a DJ playing CDs or someone behind the bar with an iPod playing his or her favorite songs.
We're talking about music and the law. My guest is attorney L.Kevin Levine. I'm Dan Ringer, and this is The Law Works. So I think I'm a little bit confused. If I go into a restaurant and I hear them playing music over the speakers, then ASCAP, BMI, and CSAC are going to be interested in that restaurant.
Absolutely.
If they're playing a radio station over the speakers, are they likewise going to be interested in the restaurant?
They're likewise going to be interested in the restaurant. It very well may be that particular restaurant, based upon its size and speaker setup, might be exempt from having to remit public performance royalties. But again, that's a very specialized or a very narrow, I should say, exception.
Do they still have to talk to these three entities?
I will tell you that as a general rule, you don't want to ignore them. They have been in existence. Certainly BMI and ASCAP have been around for quite a while. CSAC is a rather latecomer in the United States. But you don't want to ignore them. You want to certainly open up a dialogue if you're a venue owner, because more or less you're going to end up having to license the music.
Well, I've heard stories, of course, by the time they get told 2 or 3 times.
Absolutely.
It's some large fellow with a felt fedora and a baseball bat comes to visit the bar owner or the restaurant owner and wants to know, why are you playing music and you don't have a license? Does that stuff really happen?
I cannot say that I have witnessed that happening. But
well, except maybe for the fedora and the ball bat.
Exactly. But I will tell you that ASCAP and BMI, they do an excellent job, and I'm sure CSAC does too. I've had no personal experience with that particular performing rights organization. They do an excellent job looking out for the rights of their members, whether they're publishers or songwriters.
Well, and basically these organizations collect the money for playing or performing the music, and then they pay it out to the people who wrote it, the people who published it with recordings, the people who recorded the music and distributed it.
Not with recordings. Recording, actually, that gets into a whole nother territory. It's one of the things that's both neat and frustrating about the music industry is you deal with a lot of licenses, and quite frankly, it all stems from the fact that when you deal with a copyright, regardless of what type of copyright it is, you have a bundle of rights, and those bundle of rights, particularly in the music industry, most of the time you're dealing with reproduction rights and distribution rights. There are obviously other rights, but those are 2 of the big ones. Derivative use rights is another biggie. But essentially those uses are very often split up and licensed or sometimes transferred to other parties or administered by third parties. The administration, ASCAP and BMI and CSAC, for instance, they administer on behalf of their members the performance rights in the copyright. Again, that's only dealing with the underlying musical composition.
Well, you're scaring me.
That's not my intent.
All my kid wants to do is go to a birthday party and play Happy Birthday for the assembled mass masses and maybe some other songs.
Right.
Does he have to contact somebody and get permission to do these things?
Well, keep in mind, it's a little bit different when you're dealing with a private party versus a public performance when you're in a bar or
well, they're going to sell tickets.
Selling tickets is a little different. I feel fairly confident. And I'm sure this will come as no surprise to you. It almost always turns on the facts of the particular use. I mean, you know.
The favorite lawyer phrase is, it depends.
It absolutely depends.
But they do have to be aware that other people have rights and interests in these songs that they're
Absolutely. They have to be very, very mindful of that. And to just kind of take it in a different direction as far as the recording aspects go, that's when you get into an issue with what are known as the mechanical rights. And that's one of those terms that a lot of people have heard of, and quite frankly, it's arguably an antiquated term because it harkens back to the days of when we actually had player piano rolls and you actually had true mechanical reproduction of music.
Well, he's not going to do anything mechanical. They've got some microphones. They've got a computer. They're going to plug the microphones into the computer. It's not quite that easy. But they're going to record the music on the hard drive of the computer. They're going to post it to YouTube.
It's the same thing. Even though they're still called mechanical royalties and mechanical rights, it's still dealing with the same issue. Essentially, if you are a songwriter and I want to record one of your songs, okay, I have to get your permission. Particularly if it's what we call a first use. If you've not recorded it and released it commercially and not given anyone else permission to do it, I have to get a license from you for that first use. If you have given someone else the right, in other words, if we're in a true cover song situation where to go back to your example, your son and his bandmates have heard another song, they just want to cut another version of it, that is when we get into what's called a compulsory mechanical license scenario. In other words, you may not like my type of music or the way that I want to take the direction of your song. If you've already given granted someone a mechanical license and given them permission to record and sell or release your music, you can't prohibit me from doing that. There is a compulsory mechanical license under the federal copyright law.
So once the song has been publicly performed or licensed to be publicly performed, then I can't deny you the right to perform it? That's
forget about the performance. This is solely on if they want to record it on their computer and sell copies on CD, or if they want to upload copies for sale to iTunes or Amazon or whoever it is. You have to obtain a mechanical license from. Usually, you're going to obtain it from the music publisher because. Certainly if we're dealing with a very popular song, you're going to be dealing with a songwriter or usually a group of songwriters that have signed a music publishing agreement and have transferred the ownership to that publisher.
Well, okay, I'm not going to record the same song. I'm going to do a parody of it.
Okay.
How much do I have to change of it, or what do I have to do to be allowed to do that?
Oh, that's a hard question to answer.
It's one that Weird Al Yankovic has had to answer many times.
It is, and quite frankly, there are historically there have been some very, very important cases on point. The bottom line is if it's parody, there is a what we call I wouldn't call an absolute exception, and there's certainly not an absolute license, using that term loosely, to make a parody. You have to be very careful, and actually there have been a number of cases that have been have cut the other way. I mean, when you listen to a song, you think, "Wow, this is a total parody. They're making fun." But in essence, the courts are very, very careful into what they actually label a true parody.
Well, and I suppose you've got issues of the tune and the lyrics, which may be owned by separate people.
Absolutely.
And if you use the same tune but different words, you may not have to pay the guy who wrote the original words, but you still may have to pay the gal who wrote the music to the darn thing.
That's a situation that does come up sometimes. Particularly, you'll have situations where, say, a song started off as a poem or something like that, and then someone, a songwriter comes along and takes those and sets them to music. That's a situation that does happen sometimes. More frequently, though, what happens is you're a great guitar player, a great piano player. I'm a great lyricist, I wish, but we get together and decide, let's write a song together. Okay. What usually happens is we have what's termed a joint work. In other words, it's a work that each of us owns an undivided 100% of the work, and each of us is free to enter into an agreement with a publishing company to exploit that work on our behalf, or issue licenses ourselves. But we do have a continuing duty to account to each other for any monies we take in. Basically, those type scenarios happen, I feel fairly safe in saying 95% of the time, because most of the time people get together with the intent to create one single undivided copyright. And very, very often, if the parties don't get together and actually have that conversation, and they don't put anything in writing, which is very, very important, and something we always advise, and it doesn't have to be a formal writing, but if they don't go to that extent, very often a court will decide, if it gets to that point, look, this is a joint work. You guys came together, you created something, you each own it.
So the default position is going to be, if you and I got together and when we left the room this song existed, then the presumption is you and I wrote the song, unless we have evidence otherwise.
I wouldn't go so far to say it's a legal presumption, but I will go as far to say that practically speaking, that's the way it turns out almost every time.
And then when the breakup comes of the band,
yes,
what are we going to do with all this music that we wrote?
Dan, you sound like you've been in a band before, because that's a situation that in my experience, happens a lot. And going back to one of the very first things I mentioned, why it's so important to get your band business in order before you start thinking about, hey, let's start booking gigs and let's start thinking about going in the studio. It's important to lay out all those issues and have a realistic talk about it, because quite frankly, it's almost, it's always a matter of negotiation between the parties. The problem, certainly in my experience and in the experience with most bands, particularly what we call baby bands, which are, it's not a derogatory comment,
it's
but
my
just
son's band.
Brand new bands that have not been established for long. It's a very, very common problem that, frankly, most musicians, and I've been a musician all my life, so I can say it fairly, most musicians don't like to deal with business issues. We like to get together and make music. And I always advise my clients, look, if you're wanting to start a band, it's best to schedule some time very, very early, really even while you're thinking of band names. Don't even have a guitar in the room. Go someplace else and talk about the band business. And there are just so many issues from band ownership to who's going to own the band name, because again, you're dealing with trademark and service mark issues that is intellectual property.
And those fights,
yes,
when the band breaks up, are relatively common.
Absolutely.
And you referenced legal presumptions as opposed to practical presumptions a little while ago. There are legal presumptions when you form a business, whether it's a band or a machine shop or anything else. And the presumption is, in the absence of anything else, if there's more than one person involved, the people are partners. And in the absence of anything else, they're equal partners. So if Kevin is the creative one, and I merely am whacking on the drums in the background, I guess you'd be whacking on the drums in the background,
right.
You're the drummer. One of us may just be along for the ride, but we're kind of achieving 50% of whatever it is we do together.
That's right. And in my experience, what usually happens with bands, and again, everyone has different experiences, but as a lawyer, I will very frequently have what I would call a lead player, or at least a lead band member, approach me and say, look, I've written a lot of songs, I've gotten a group of people together, and even though we are a quote unquote band, I want to ensure that all this intellectual property is mine. I want to ensure that they know that I am the leader of this band. And the unfortunate reality is a lot of times this doesn't happen until a year down the road, and quite frankly, they're on their third bass player and their second keyboard player, and so you have a lot of those issues that can come into play. And a lot of times, you of course don't find out many of these things from your client until down the road, but I may not have mentioned the keyboard player, wrote 3 of the songs that are on the CD we're releasing next week. Those are the type of things that happen and that really need to be nailed down. If it's a non or if it's not a formally organized entity that you're doing, like an LLC or a corporation, certainly you need to enter into what we call a band partnership agreement, which lays out all those particular issues that can come up.
Right. While the law may presume that we're going to be equal partners, that doesn't mean we can't agree to be something other than that. We can be unequal partners. There can be other people involved. There can be people involved who are not partners. Lennon and McCartney wrote an awful lot of songs, but Ringo didn't get any of that part of the action because he didn't help write the songs. Right. He just whacked on the drums in the background. Kevin Levine, thank you very much for being with us.
Thank you.
Thank you also for being with us. On behalf of the Law Works, I'm Dan Ringer. Good evening. If you have a legal problem and want to know if you need a lawyer, you can discuss your problem with a lawyer by calling 1-800-642-3617 Tuesday evenings from 6 to 8 p.m. That's 1-800-642-3617. On the LawWorks webpage at thelawworks.org, you'll find a listing of recent The LawWorks program topics and additional information about this show's topic. If you would like to recommend this program to a friend, you'll find a video of the program at the LawWorks website. You'll also find free video and podcasts of previous programs on YouTube and iTunes. If you would like to suggest a topic for a future program, or if you're a school teacher and would like to receive a free copy of this show for classroom use, send us an email to thelawworks@comcast.net.
The Law Works is produced in cooperation with the West Virginia State Bar, the Mountain State Bar, and the West Virginia University College of Law. The Law Works is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
From West Virginia Public Broadcasting.